Now I'll ask John a question, which is, why don't we talk about probable cause, and why didn't that protect child number 2 in this situation?
Because probable cause is specifically not included within the rubric of what Shirley has defined as indirect contests, so that if the no contest clause makes reference to creditors' claims or to the characterization of property, as Shirley has described, without more, that no contest clause will be enforceable regardless of whether the contestant had probable cause, if it's in the nature of a creditor's claim or a transfer of property, which brings up a planning point for those who do, in fact, drafting. I am, the reasons that this probable cause exception does not apply to those 2 subtopics is political. Had to do with the biases of some of the commissioners on the Law Revision Commission, and we won't have to go into that. But I say, as a drafter, I don't see a substantive difference between probable cause for a direct contest and probable cause for either a creditor's claim or a transfer of property, because the transfer itself could have been the result of one of the prohibited actions, or the creditor's claim could be a justifiable one. So when I draft a no contest clause, which has become increasingly rare for me, but when I do, I put in the probable cause exception for both creditors' claims and property characterization disputes, and I suggest that you consider it when you're drafting no contest clauses, because this can be a trap for the unwary. Well, I have one question for you, Shirley.
Oh, all right.
Should a no contest clause cover future beneficiary designations? That means beneficiary designations signed after the date of the trust agreement.
And the answer to that is no, because it's completely, under the law right now, completely ineffective. Remember that there are 2 requirements one for an indirect contest. One is that they be in existence, and the second is that they be specifically mentioned in the no contest clause. Even though you specifically mention it, as to future amendments, it's not going to work, because the First Amendment is not in existence at the time of the original trust agreement. However, keep in mind that your past documents can be incorporated, and you can mention those, and the statute expressly allows you to make a protected instrument anything that you've signed up to date. So, you may want to clean up things where you've done a trust agreement, and contrary to your advice, the client has not yet signed all the beneficiary designations. When all that gets done, the life insurance and so on, then you might want to consider doing a First Amendment to refer back to those instruments that are now, quote, in existence.
Which always raises the question in my mind when I have clients, why do you want to leave property to someone that you want to punish for with a no contest clause? But that's a philosophical debate that my clients don't want to have.